Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you.
Start. The appellant impugns a judgment arising out of the claim petition whereby a petition under section 166 of the Motor Vehicles Act was dismissed by the Motor Accident Claims Tribunal on the ground that the appellant had failed to establish that the accident was caused on account of rash and negligent driving on the part of the first respondent of Maruti van stop. The said vehicle was owned by the second respondent, financed by the third respondent, and insured by the fourth respondent stop. Para. The manner of accident as stated by the appellant and the defense of the first and the second respondent as stated in the impugned judgment is extracted hereunder full colon para. It is alleged that on the night of 26/5/1994, petitioner was returning back to his residence on his car via National Highway stop. On reaching the right turn towards Mayur Vihar, he stopped his car at crossing on the left side of the road because he saw two speedy vehicles coming from the side of Ghaziabad stop. One of those vehicles was an ambassador car moving on the left side. A Maruti van was trying to overtake said ambassador car at a very fast speed from right side stop. When those vehicles reached near crossing, the driver of van lost his control as the driver of ambassador car apparently reduced the gap between his car and Central Verge stop. The Maruti van driver, in order to avoid hitting the Central Verge, took a sudden right turn of about 160 degrees stop. Consequently, he hit the stationary car of the petitioner stop. Due to the impact, Maruti van overturned and the car of the petitioner was badly damaged stop. Petitioner sustained serious injuries on his right eye, nose, forehead, and face, etc. Stop. Para. Respondent numbers 1 and 2 have filed a joint written statement. Stop. They have admitted the impugned accident. Stop. They have also admitted that respondent number 1 was the driver of the offending Maruti van and respondent number 2 was its registered owner. Stop. According to them, the offending van was insured with respondent number 4 insurance company. Stop. These respondents have denied the allegations that respondent number 1 was driving the Maruti van at a fact speed or that said van was overloaded or the impugned accident was caused due to rash and negligent driving of van on the part of respondent number 1. Stop. Respondent number 1 and 2 have also alleged that the claim of the petitioner is excessive. Stop. Para. The claims tribunal framed the issues by an order dated 8/5/1998. Stop. During inquiry before the claims tribunal, it was brought on record that an FIR under section 279 was registered against the appellant. Stop. A charge sheet was also filed against him. Stop. In fact, these facts were not disclosed during inquiry before the claims tribunal by the appellant. Stop. It was only when an application under Order 18, Rule 17A was moved by the first and the second respondent that it was admitted by the appellant that the police registered an FIR against him and that he was also convicted for the offence of rash and negligent driving for the accident in question. Stop. The appellant's plea before the claims tribunal was that the finding of the criminal court was not binding on the claims tribunal, and since his evidence had not been repudiated, it will be treated as sufficient proof of negligence on the part of the first respondent. Stop. This plea of the appellant was rejected by the claims tribunal. Stop. Para. The judgment of another case relied upon by the appellant was also distinguished as not being applicable to the facts of the present case. Stop. The claims tribunal did not find merit in contention of learned counsel for the petitioner. Stop.